Hi, everyone. My name is Christine Mathias. I'm an attorney for public good. And in this video, we'll cover what California nonprofits should know about working with commercial fundraisers. Many charities handle fundraising themselves, but others hire outside help. That includes fundraising consultants, joint ventures, or commercial fundraisers. So, today we're going to focus on commercial fundraisers in California with the goal of helping charities and donors understand the rules. A commercial fundraiser is one who receives compensation from a charitable organization to directly engage in soliciting, receiving, or controlling funds or assets for charitable purposes. But note, charity employees and board members are not considered commercial fundraisers. And also note this is different from fundraising counsel. Anyone who maybe advises a charity on fundraising, such as an attorney, would just be considered fundraising counsel. But the key difference is that counsel does not solicit funds or control assets of the nonprofit. So, commercial fundraisers are watched more closely than any other fundraiser helpers. And there's a reason for that. They often take a big cut of the donations, sometimes even more than half of the donations. And although that is legal, it is highly regulated, and this can be very costly to the organization. All commercial fundraisers must register with the California Attorney General before engaging in any commercial fundraising. So, if your nonprofit wants to hire a commercial fundraiser, it's important to make sure the fundraiser is actually registered. There's a few more registration reporting requirements. The fundraiser must post a $25,000 bond and renew the registration every year. They also must give a yearly financial report and maintain financial records for at least 10 years. Also, know commercial fundraisers can only fundraise for nonprofits that are registered with the Attorney General. So it's important to make sure you are up to date with your AG registration before you hire a commercial fundraiser. Commercial fundraisers must file a notice of intent to solicit with the Attorney General at least 10 days before starting any campaign. In addition, if they're asked by a donor, they must tell them the percentage of donations that will be going to fundraising costs, and they must tell the donor that they are, in fact, a commercial fundraiser. In addition, they cannot lie or be deceptive about the charity or about how the donations will be used. Before fundraising, commercial fundraisers must have a written contract with the charity. And there's a few key details that must be included in that contract, including the charitable purpose of the fundraising activity, the obligations of both parties, the effective and termination dates, and the fee arrangements. Now, that might be fixed fees or a percentage of amount raised. The contract also must allow the charity to cancel the contract within 10 days without any cost or penalty to the charity. And finally, payment to the charity must be made within 5 working days of the fundraising activity. Overall, these rules are important for both charities and for donors. Charities are ultimately responsible for what their fundraisers do, and they cannot hire unregistered fundraisers. But note the agreement is hugely important. It's essential that you understand what your payment structure is and what cash controls are in place to protect your nonprofit.